Good day and welcome. Employment Law Show. John Scholes, Lior Samfiru, back here for you. The knowledge is going to be spread over the next 30 minutes, so listen to every single morsel of it and take it all in. You want to reach out to Lior and his team anytime. Phone numbers first, 1-855-821-5900. Email, which we will get to some today on the show for sure, help@employmentlawyer.ca. And the shorter version of that, simply employmentlawyer.ca. The website is a place where you can catch links to our long-running radio show. We'll play some calls back from the radio show today as well. But Lior, as always, we're going to start with a bunch of things. We're going to get to non-competition and non-solicitation clauses, what those all mean, what they're all about. That's probably in the next segment. But stuff to get through before then. The week that was, what's going on with you, pal?
John, always busy time for me. Certainly the last year plus with the pandemic has been crazy busy because employment law issues have come to the fore more than ever. I don't know anyone whose job has not been impacted in some way by COVID-19. So chances are, if you're watching us right now, you felt that impact. Maybe it's been a good impact. Maybe you're busier than ever and things are great. For many people, it's not so fortunate. Your job or your hours, your compensation or your job security may have been impacted. Maybe you're not working right now. You're off on a layoff and you want to know how long you need to be off or you can be off and what to do about it. We'll cover that on this show, on every show. So if you have any issues, questions, you've always wondered about something, you're watching the right show right now to educate yourself about employment law issues. That said, we only have 30 minutes, so we may not be able to cover everything. That's why we give you that contact information so that you can reach out to me off the show, off air, so we can have a private discussion about your situation and get you that help that you need. So this is the Employment Law Show dealing with workplace rights. So let's get to it. John, I had a call this week from a gentleman who had been laid off for a long time. He'd been laid off since the spring of 2020, of course, because of COVID-19. Now, he was initially quite optimistic that he'll go back to work, and that kind of got extended, and he has not been back to work since. But, of course, he's not able to just live off EI and other government support. So what he did, probably about 10 months or so after the layoff started, is he found another job. And he started working in that job, still hoping that he'll be called back to work to his old job at some point. But in the meantime, he had to earn income, put food on the table. So his old employer found out about this job, and they contact him, and they say, well, we understand you're now working somewhere else, fine, but we consider that to be a resignation, so you're not coming back, off you go. He was, of course, upset. In fact, he was livid about it. He's been waiting for the company. Now they're saying that he's resigned. So he contacted me, and he wanted to know, is this a resignation? Did I actually do something wrong by finding a job so I can support my family? Well, John, of course he did nothing wrong. Here's how this works. When he was actually laid off last spring, okay, that layoff was a termination. By laying him off, the company put him in a situation where he can demand severance. He can treat that as a termination. So, in fact, he's already been terminated. He can't resign because he's been terminated. Same with you. If you've been laid off temporarily, you have a right, if you want, to treat that temporary layoff as a termination of your employment and say, I am not waiting, I am not sitting and hoping and following up. I'm simply going to demand and get my severance. You can do that today, you could do that tomorrow, you could do that at any point. If you want to do that, give me a call. Now, the other thing is this. If you don't want to do that, if you want to sit and wait for your old employer to call you back to work, you can find another job. And by finding another job and working at another job, that's not a resignation. You're allowed to do that. So either way, this company did something wrong. I'm going to help him get severance. He's owed about a year's pay. He's been with this company about 14 or 15 years. I'm going to get him that year's pay. So remember that lesson here. If you've been laid off temporarily, yes, you can treat that as a termination. You can get your severance. If you don't do that, if you want to wait, you are allowed to work somewhere else while you're waiting.
What are the pitfalls if he had just said, okay, you know what, I'm going to sit and wait and hopefully they bring me back to work?
Well, the obvious pitfall is, of course, well, he's sitting and waiting, not earning an income, and he may never be called back to work. So essentially, he's sitting there and waiting for potentially nothing. But it gets worse if, in fact, they do call him back to work. Potentially getting called back to work puts him in a worse situation, because getting called back to work from a layoff and accepting that recall means you've given the company the right to do it again. So when they lay you off a second and a third and a 10th time, you won't be able to do anything about it because that first time you let it happen. So that is a consideration that everyone should keep in mind here. If you have been laid off temporarily, if you accept it, if you do go back to work, obviously that's your right. But by doing that, you've given the company the right to do it again. That is potentially very problematic.
If you do decide to pull the trigger and get severance and get out of there, not stand by on this temporary layoff, has COVID-19 made any difference to the amount of severance? Are the employers trying to play that card?
Employers are trying to play that card, but the law is very clear. Not only do you not get less severance because of COVID-19, you actually get more severance. And the reason for that is it's going to be more difficult to find another job now. It's going to take you longer to find another job because of COVID-19. That means more severance. So it's that much more important. I've been saying on this show for years, if you lost your job, you have to give me a call. We have to review your severance offer because chances are it's completely inadequate. Now, during COVID-19, that's more important than ever. You're owed even more than usual. So please make the call, send the email, do the right thing if you lost your job.
And as always, we throw it up on the screen, but 1-855-821-5900 is the way to reach out. Employmentlawyer.ca, the website. Go there. Lots of information. Also links to finding our long-running radio show pretty much across the country. You'll find a station near you where you can tune in or online as well. We take some of the phone calls, as you know, Lior, from the radio shows. We handpick some interesting ones. We play them back here, and we talk about them. Today's first phone call is coming up.
I was working for a job for 4 years. And 4 months ago, I got demoted from full-time to part-time, 15 hours a week. And I was recently laid off. Should I be getting severance at my full-time pay or my half-time, part-time pay?
It's a great question. Great question.
It's a great question. So here's how this could have worked, and here's how it is going to work. So 4 months ago, she was moved from full-time to part-time, okay? She did not have to accept that. Her employer did not have a right to reduce her from full-time to part-time, even if it's because of COVID-19. Meaning, she could have said, by doing that, employer, you've terminated my employment. Now you have to pay me severance. If she had done that back then, she would have gotten severance, let's say about 6 months' pay, based on her full-time wages. She didn't do that. What she decided to do instead is accept that and continue working with that pay reduction, going from part-time or from full-time to part-time. The problem is that now, when her employment is terminated, the severance she's going to get is going to be calculated based on her part-time wages. So even though she's only worked part-time for a few months, now that she's terminated as a part-time employee. So if before she was making $50,000 a year, now she's making $25,000 a year, the severance is calculated based on that $25,000. That's why it is so important not to accept changes to your pay, to your hours, changes that are negative to you. Because not only do you give the company the right to do it again, it could also impact your severance. Effectively for her, she lost half her severance because she accepted that reduction from full-time to part-time. If your employer wants to change terms of employment, before you accept, before you say anything, call me. Let's talk about that. Let's make sure we deal with it the right way.
Yeah, you always raise the alarm bell when you're drifting into constructive dismissal territory, always, and that's a perfect example, right?
That is exactly right. It is a constructive dismissal when your employer wants to change terms of employment in a significant way, from full-time to part-time, reduction in pay, change in hours, change in shifts. None of those things are things that your employer is allowed to do. The law looks at it as a constructive dismissal.
Another place for you to go anytime, terminationquestions.com, terminationquestions.com. You have questions for Lior or his team. You can write them in there, leave them, they will be answered. And we'll get to one for today, Lior. This one for the first show today is Marilyn. Marilyn writes in, says, I was let go after 5 years with my employer. My firing was tied to the fact that I asked for 2 personal days. Following a month of endless 12-hour shifts, they asked me to work temporarily. After asking about my mental health, they sent me 4 weeks' pay and said that I should have no problem securing a new job. Can they do that?
Well, there's certainly at least a couple of things to unpack here. So let's start with the idea that, well, we know she's been let go. Her employment was terminated. Well, if they think she may have a mental health issue or some other condition, and that's why they let her go, that's a human rights violation. And by the way, John, it doesn't matter whether in fact she has a medical condition. If they believe that she does, and that's why they let her go, that is a human rights violation. That's illegal. You cannot be let go because your employer perceives you to be disabled, because your employer perceives you as having a medical condition. If your employer lets you go because of that, that's illegal. It's a human rights violation. They're going to have to compensate and pay damages. So that's issue number one. Certainly we need to find out more about that. The second issue, she's been there for 5 years. Her employer says, here's 4 weeks pay, off you go. Nonsense, ridiculous. She is owed much more severance than that. I can tell you exactly how much she's owed, but so that you can see how it's calculated, let's take her information and let's plug that into pocketemploymentlawyer.ca. You can do that yourself for your own situation. Pocketemploymentlawyer.ca. You can see on the screen right there, she's been there for 5 years. Let's say she's in customer service, 54 years old. Her employer says, we're nice, we're going to give you 4 weeks pay. Well, you can see on the screen right there on the bottom, what she's actually owed is 6 months pay. 6 months pay. That makes this a wrongful dismissal. By the way, if you lost your job, are worried about losing your job, your friend lost their job, place to go to find out how much you're owed, pocketemploymentlawyer.ca.
All right, little break. Next thing we're going to tackle non-competition clause, non-solicitation clauses. What are those all about? We'll break it down after a short break. 1-855-821-5900 and employmentlawyer.ca.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, welcome back. Employment Law Show. John Scholes here and Lior Samfiru, of course, answering all of your questions, emails, get to some phone calls, and then we break down some terms because people just don't know what they mean, so we clear it up. Non-competition clause, non-solicitation clauses. Let's handle the competition one first. What is a non-competition clause, Lior?
So a lot of people have heard the term non-competition or non-compete. So really what that is, non-compete is a term in an employment agreement that says that if you ever leave the company, whether you quit or are let go, if you ever leave, you cannot work for a competitor. So usually we'll also define what's considered a competitor, who is a competitor, and it will also usually say within what geographic region. So within this province, within the country, within the world. So non-competition is a term that tries to prevent you from working for a competitor for a period of time. I've seen them anywhere from 6 months to 5 years. So, and it's a common term. Most people now, when they sign employment agreements, sign that. But you want to keep in mind that because, in fact, it could significantly, we'll talk more about that in a moment, impact your ability to find another job. If you can't work in an industry that you've worked in for many years, if you are let go, that could be a huge problem. So non-compete tries to take you out of that market. It tries to take you away from working for a competitor for a period of time, and that is quite problematic.
The cousin of the non-competition is the non-solicitation clause. What's that one all about?
So non-solicitation or non-solicit. A non-solicitation clause is a term that says that if you leave, again, let go or just quit, you cannot go after customers. You cannot solicit business from the company, your old company's customers. What the employer doesn't want is that you leave and take business away from them. Now, it doesn't say you can't work for a customer or you can't accept business from a customer. You just can't be soliciting them. You can't be knocking on the customer's door and say, hey, customer, I now work over there. I want you to send me your business. I'll give you a better rates, etc. So non-solicitation protects your old employer's business, protects your old employer's clients, and most employers use that. Now, non-competition, I think a good percentage of employers use. Non-solicitation, almost all employers use. So chances are, if you are accepting a new job, if you have an employment agreement, a written employment document, In that document, there will be a non-solicitation provision, and you have to be wary of that. You can't just necessarily go across the street to work somewhere else and then hope that you can take all the business that the old employer had. Not if you sign the non-solicitation agreement.
How do these two rank as far as being enforceable is concerned?
Well, let's tackle the non-competition first. So I'm going to tell it to you the way it is. For most people, a non-competition term is not enforceable. What our courts have said is we don't like terms that prevent people from earning a living. We don't like it, we don't accept it. So for most people, a non-competition obligation or non-competition term is not enforceable. A court is not going to make you not work for a competitor. A court's going to allow you to work wherever you want to work. Now, for some people, generally very senior individuals, fiduciaries, for those individuals, yes, the non-competition may be reasonable, may be enforceable, as long as it's reasonable, as long as it's not for a long time, as long as it's not across the country. Yes, it may be enforceable. But for 95% of individuals, even if you signed it, the law says, not enforceable, not fair, not in accordance with public policy, so we're not going to enforce it. Now, the cousin, as you say, the non-solicitation obligation, unlike the non-compete, is enforceable for most people. So if you sign that document saying that you can't go after customers for 2 years, for most people, that will be enforceable. So if you decide to breach that, you are certainly taking a big risk. You potentially can get into legal trouble. And with the non-solicitation clause, yes, you do have to abide by it.
There's going to be those who think, hey, you know what, it's in my agreement. It's like page 4. I'll just ignore it if I leave. Advisable? No?
Well, some people everyone just heard me say, well, a non-competition obligation is not enforceable.
Right.
Great, we can ignore it. I can go work wherever I want if I quit or if I'm let go. Lior said on TV that it's not enforceable. And I'll say it again, it's not enforceable. But the fact that it's not enforceable doesn't mean you can't get into huge trouble if you decide to breach it. And here's what I mean by that. The real question is not, is it enforceable? The real question is whether your former employer will try to enforce it. And if they do, they'll take legal action against you. They'll sue you. They may sue your new employer, and you'll be embroiled in a very long and expensive legal battle. Now, you will win that battle because, as I said, it's not enforceable. But that battle will still be a pain in the rear end. Okay, it's not going to be easy. It's not going to be fun or friendly or cheap. So you have to take it seriously. You are taking a huge risk if you ignore a non-compete. Even though it may not be enforceable, if your former employer tries to enforce it, you'll be in trouble. So do not ignore it. Take it seriously, and wherever possible, try to abide by it.
How about the non-solicitation? Is there a chance you can ignore that or no?
I would not ignore that, not unless you speak with the employer. Now, with a non-solicitation, what I would do is make sure you make it clear to a prospective customer that if they want to come to you, I didn't solicit your business.
Right.
You came to me, that's fine. You can protect yourself in that situation. But if you go after your old company's customers, you knock on their door, you send them emails, you phone them up. If you have a non-solicitation in your old employment agreement, you potentially can get into trouble.
So someone comes to me, they've got a juicy new employment opportunity for me, but damn, I got that non-compete in my employment contract. How do I handle it? Because this is an opportunity.
Well, first thing you have to do, and you absolutely should do this, is tell the new employer about the non-compete.
Right.
They need to know about it. Because if you don't tell them and then there's legal action, they'll let you go because you weren't honest and you potentially got them into trouble. So the new company should know. A lot of them may not care, but they should know. The other thing you may want to consider is speak to your employer, your old employer, and say, listen, I'm going to work somewhere else. I'm not going to hurt you. I'm not going to solicit clients. I'm not going to hurt your business. But I want you to understand that I'm still going to work for a competitor without hurting your business. Most employers are going to be receptive. They're going to understand. So it is a good idea to have that discussion. The risk, of course, is this. The risk is if you don't do that and your old employer finds out you're working for a competitor, they will take legal action. Again, you will win that legal action. I can almost guarantee it. But it's still not going to be a pleasant experience. So ideally, you want to avoid that altogether. Be open with the new company, be open with your new employer, and try to work out a deal, a situation where you can go work wherever you want, as long as you don't go and solicit and take their business.
Well, that was kind of where I was going with the last question. That is, if I am the soon-to-be former employer, how do I protect that from losing my good employees to competitors?
So first of all, employers should use non-solicitation agreements or non-solicitation terms in employment agreements. Every employer should have that. And you have to be reasonable with it. So in other words, if you say you can't solicit our clients for 5 years anywhere in Canada, you've overreached, and that's not going to be enforceable. But if you say you can't solicit for a year, within 50 miles of our office or something like that, then that's fine. So employers have to be reasonable. With respect to non-compete, if you have senior employees, yes, use non-competes for them. I wouldn't necessarily bother with more junior employees. Use them for your senior employees and use non-solicitation obligations for all employees.
Again, questions anytime, either the phone call, 1-855-821-5900. Employmentlawyer.ca is the website. That is also where we get our phone calls for this show from our radio shows, which you can find on the website as well. Lior, phone call number 2 from our radio program is coming up.
When I was hired, I had a 1-year contract. The 1-year contract expired, and I continued to work there until April of last year. When COVID hit, basically locked the place down and so on and so forth. And just wondering what my status would have been, not like working for almost 5 years without a contract. And I am an independent contractor.
So first of all, let me spoil the ending, which is he's not an independent contractor.
No.
Okay, he's an employee. Yeah. If he's worked there for 5 years, it's almost always going to be a situation where the law considers you to be an employee. And that's sometimes very difficult for people to accept. It's like, I signed a piece of paper that says I'm an independent contractor. I pay my taxes as an independent contractor. The company I work for says I'm an independent contractor. So how can you tell me I'm not?
Right.
Well, I am telling you that because the only one that can decide what your status is, not you, not the company, is the law. And if you look like an employee and act like an employee, if you have a regular job, you are an employee of that company. So chances are for this person, he's been misclassified as an independent contractor when he truly is an employee. Now, that's important because now he's been there for 5 years. The old contract expired. He's now employed under an oral agreement. So he's a 5-year employee. If he's let go tomorrow, he's getting severance like a 5-year employee. The company may say, we don't have to pay you anything. You're an independent contractor. We're going to let you go, shake your hand and say goodbye. Not so fast. If you've been misclassified, and this whole time you've been an employee and you've been let go, you're owed severance like an employee. That could be up to 24 months' pay, 2 years' pay. So important. If you think you're an independent contractor, call me. Let's talk about that. Or by the way, pocketemploymentlawyer.ca has a tool that allows you to find out if you're an employee or an independent contractor. So definitely check that out, pocketemploymentlawyer.ca.
And quickly before we break, you mentioned he's kind of on a handshake agreement now that that's over. That's the best way to be employed, isn't it?
Absolutely. I want, if I had my way, if an employee had his or her way, all employment arrangements should be on a handshake. You, as an employee, you don't want an employment agreement. You don't want that 5 or 7 or 10-page document. Oral agreements, handshake agreements, back of the napkin, all of those are much, much better than having a long employment agreement that all that does is it gives employer rights, not the employees.
We'll get to another phone call from our radio show, but we've got to take a short break first, so we will do that. 1-855-821-5900 anytime and employmentlawyer.ca.
People think you aren't owed severance pay if you are fired for a reason. Employmentlawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at employmentlawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. Employmentlawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at employmentlawyer.ca.
All right, welcome back. Thanks for hanging out to Employment Law Show. We'll get to our third phone call from our radio show. Again, you'll want to find a station near you that carries the program wherever you are in the country. Simply go to employmentlawyer.ca. Let's get to that call.
Companies that I had been laid off from due to COVID let me go, terminated my employment via email. The email stated that we've decided to not fill your position. So I was given my vacation pay plus pay in lieu, a little bit of less than a week severance. And I'm wondering, I was only with the company for about 7-8 months, but it seems to be a little bit on the low side.
Very good call, very good question. It's certainly something we can elaborate on. So let's be clear. Company does have a right to let him go. You may not have done anything wrong, and he feels that the rug is being pulled out from under him. I get that completely. Legally, though, the company is allowed to let him go, but they have to pay him severance. Now, he's worked there for 8 months. There's a tendency, of course, to think, well, short service employee, he's probably owed a week's pay. If he's really lucky, maybe 2 weeks' pay. A lot of people believe that all the time. Wrong, false, not even close. Remember, short service employees, short service, he's 8 months, that's short service, are treated disproportionately better than longer service employees. So you're often owed several months' pay, even if you worked a few months. Don't believe me? Let's take this exact scenario and let's plug that into pocketemploymentlawyer.ca and see how much this person is owed. So this person has been there for 8 months. I don't know what his role is. Let's say he's a manager, 56 years old. He was given a week's pay. You can see right at the bottom of your screen, he is actually owed anywhere from 3 to 6 months' pay. He's worked there only for 8 months. 3 to 6 months' pay is how much severance he is owed. Not a week, not 2 weeks, not a month. Same with you. If you lost your job, free, anonymous, easy to use, your best friend, your best resource, pocketemploymentlawyer.ca.
Going to slide in one more quick question before we go. Lior from terminationquestions.com. Kara says the company I worked for changed ownership a few weeks ago. I was told by the new owner before the change that I would be kept on, but they needed to pause my job for a while before bringing me back. Now they're not returning my calls. What should I do?
So, listen, employment is actually not complicated, the employment relationship. You go to work, your employer gives you work, and that's it. If your employer doesn't do that, you're off work, they're not giving you work, they're not calling you back, whatever you want to call it, that is a termination. You can't be employed if you're not working. You can't be employed if your employer won't give you the ability to come into work. So for this person, for Kara, her employment was terminated, any way you slice it. It's been paused, her employer's not getting back to her, whatever that is, she now can say, that's it. Enough is enough. I've tried to come back to work. You're not giving me work. I've been sitting at home for a while. That is a termination of my employment. And now, like it or not, employer, you have to pay me my severance. That's what you can do. And same with you. If your employer is not getting you work, if you've been put on a layoff, on a pause, on a leave, and you're not working, that in the eyes of the law is a termination. If you want to get your severance, remembering, as I said earlier, that it could be as much as 24 months' pay, if that's what you want to get, give me a call. I'll help you do it.
It's like if you think about it in the reverse. It's like, okay, I got this new job. You know what? Don't feel like coming in for a few months. I'm just going to hang back. And, when I feel like coming back, I'll be in.
But it's exactly that, right? If you decide, well, I'm just not going to come in, but clearly I'm still employed, that would be silly. And your employer is going to say you've resigned. Well, it's the same thing in reverse. If your employer won't give you work, won't give you a job, you're not employed. They can't keep you employed. They can't call you an employee unless they're employing you, unless they're giving you work, and then they have to pay you your full severance.
Always think about that, the reverse, whenever you're talking about employment law. And when the show's not, I'm going to give you some contact as we wrap up for the day. That came from terminationquestions.com. You can go there anytime, ask your questions. You got all kinds of time there. Pocketemploymentlawyer.ca is like having Lior with you constantly. And 1-855-821-5900. We'll catch you again on the Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.
People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.